Mark is a human rights activist. He's a champion for access to palliative care, but you will all remember him from the TAC, Treatment Action Campaign approach of the Constitutional Court in the case, or appearance in the Constitutional Court, Minister of Health versus the Treatment Action Campaign, where the Constitutional Court ordered the government to provide antiretroviral medicine to HIV positive pregnant women. That was a remarkable case, of fighting for human rights, of speaking on behalf of voiceless people. So it's wonderful for us to have Mark with us. He's also an advisory trustee to DignitySA. And we've asked him to talk about, or he suggested that he would talk about building a movement that can leverage the Constitution to secure the last right, the right to medical assistance with dying. Thank you, Mark.
Thank you, Willem, for that kind introduction, and good afternoon, friends and colleagues. I'm very grateful for the trust that Dignity South Africa has placed in me this afternoon to give this keynote speech on an issue of such importance and an issue of such sensitivity. Before I start speaking, I also want to thank Dignity South Africa for the pioneering work that you have been doing for 15 years around dignity in life and dignity in death, around the pillars of work that were outlined by Vuya, and specifically now around this critical constitutional case that is being brought to the courts to try to legalize medical assistance in death. It has my full support as a human rights and a social justice activist, as one of the founders of the Treatment Action Campaign. And I'm here in part to indicate that the networks that fight on a daily basis to advance people's health rights and life rights will also stand beside you in this campaign to secure dignity in death and access to medical assistance in dying. As Willem said, the title that Lee gave me, or that was given for this afternoon's presentation, was Securing South Africa's Last Right. And I spent quite a lot of time puzzling out what was meant by that. And I only clicked this afternoon, actually. And I'm not sure if it's a deliberate pun on last right and last rights. But that's what I will talk about. But as I struggled to make sense of the title, I gave it a subtitle as well, which speaks to the main title, and I'll come back to in my concluding comments. But what I really want to speak about is the right of access to healthcare services, where I say everyone, which is the language of the Constitution when it comes to health, is everyone, i.e. every person, making the case for dignity in life and dignity in death. So that's what I'm going to talk about. And fortunately, I hope that what I'll say in the next 15 or so minutes aligns very much with the introductions from Vuya and also from Willem, because I am going to center a lot of my comments on the Constitution, on the use of litigation, and how we should understand medical assistance in death. And I want to build my argument from my own personal experience as a health activist for 30 years. In fact, this is where I will start. 32 years ago, almost, bar a couple of months, my first real job in life was when I was employed at the AIDS Law Project, an NGO that had been established by Justice Edwin Cameron, who I'm sure everybody knows here, to campaign and develop legal frameworks to protect the rights of people living with HIV and people who at that stage were mainly dying of AIDS because there was no access to treatment. And Edwin and Zaki Ahmad had specifically employed me because of my desktop publishing design skills, which I had acquired in the anti-apartheid struggle. And my first job was to develop 3 pamphlets around the rights of people living with HIV. One pamphlet was on the right to confidentiality and privacy if you lived with HIV. The second pamphlet was about the right of informed consent for an HIV test, because many people were being tested against their will or even without their knowledge. And the third pamphlet was about living wills for people living with HIV or people dying, in fact, of AIDS. And I produced those pamphlets, and I tried to find them for this presentation, but they're buried in an archive somewhere at WITS, I hope. Now, obviously, that was 30 years ago. That was 1994, 32 years ago, and the landscape of the HIV epidemic has changed dramatically since then. There isn't time to go into it, but I think you know what I mean. But the issues that underlay those 3 pamphlets are directly relevant and, in fact, central to our discussion this afternoon, because they were about not every person's rights to dignity, autonomy, and self-determination in a healthcare setting. Now, in those 32 years, I have spent probably 99% of those days fighting for the right to life and the right to healthy life, because most of my work has been on HIV and latterly at Section 27, the organization, and used consistently and constantly the Constitution as the bedrock of that advocacy and building movements. So you might ask, well, maybe you won't, and certainly not those who are with us this afternoon, but why then, if I've spent all my life fighting for the right to life, do I want to lend active support and give a lecture about the right to dignity in death? And I do so because there's no contradiction, frankly, as Willem suggested when he talked about dying as an essential part of life. And because what I learned fairly early on in my work in the AIDS epidemic is that the struggle for freedom and the struggle for health has actually always been about dignity, which is at the center of this court dispute. I joined the AIDS Law Project, and actually I was thinking I would only be there for a few months. I had other ambitions at that point in life. But once I started working with people like Edwin, working with people living with HIV, I realized that freedom without dignity is not freedom, and that health is central to dignity. And what struck me in 1994 was that the AIDS epidemic was about to take away the newly won freedom of millions of people by taking away their dignity. It was taking away their dignity because of high levels of stigma and discrimination, but also because for most people, there was very little dignity in illness with AIDS and in death with AIDS. So I'd been a political activist up to that point, and I concluded that the struggle for health is as much of a political struggle as the struggle for the vote, which is what it had been up to that point. So let me now just spend a few minutes talking about the centrality of dignity to this discussion that we are having. It should be obvious to you that I'm not an expert on the legal, moral, or medical issues around medical assistance in dying. I'm an activist, and my degrees are in African literature and English literature. You can ask me about that another time. But as an activist, I do think dignity is at the heart of this debate, because the question is, and it's always already been presented in this way, when dignified life becomes impossible, when dignified death becomes necessary, what are your rights, your last rights? And grappling with this question, because it's a difficult question and an emotional question and a draining question, made me recall something again that I'd forgotten about in relation to the AIDS epidemic. And it's this. One of the most influential academics and activists in the AIDS epidemic was a Canadian called Jonathan Mann. And what Jonathan Mann brought to the AIDS epidemic was a recognition that traditional biomedical approaches to AIDS weren't sufficient, that it was essential to bring human rights into the discourse about preventing HIV and about treating HIV. Now, tragically, Jonathan Mann died at the age of, I think, 52 in an aeroplane crash in 1998. But it caused me, this lecture, to look back at Mann's writings, because after he died, a few friends of mine who worked closely with Jonathan Mann, and I think Edwin worked closely with Jonathan Mann, pointed to the fact that Mann's big issue was about dignity. And I found this quotation in this article from Jonathan Mann, where he's referring to the Universal Declaration of Human Rights, and the first line of the Universal Declaration of Human Rights, which talks about all human beings are born free and equal in dignity and rights. Free and equal in dignity and rights. And what Mann says, to quote, is, "The modern human rights revolution emerges boldly from the first article of the Universal Declaration of Human Rights. Given the care lavished upon each word and phrase in the course of its elaboration, the syntax which places dignity before rights merits consideration. Dignity is clearly of vital individual and societal importance. Individuals and societies spend considerable energy in the daily effort to protect, enhance, and sustain their dignity." And I had a bit of an aha moment, because it's interesting how man separates dignity from rights, even though they are conjoined. And he sees rights as being necessary to protect and advance dignity. And that's why Willem and colleagues who've been drafting this founding affidavit, I think you're right. Medical assistance in dying is a dignity issue. And I think the resort to the Constitution is justified, because the Constitution is our supreme law and guarantor of rights. And again, I quickly squizzed the Constitution, because here it is. I don't always, I look more at section 27 than other sections. The very first section of the Constitution, section 1A, talks about human dignity is fundamental to the state that we have founded. And section 10 talks about everyone having inherent dignity and the right to have their dignity respected and protected. And that's what we're talking about this afternoon. So it's a very strong right. Now, having talked about dignity, let me talk a little bit about something that isn't reflected so much in the founding affidavit, but which, if I think you want it for advocacy or even for legal argument, supports this contention. And that is that medical assistance in dying is also a health rights issue. The Constitution says everyone has a right of access to healthcare services. It goes on to say that the state must take reasonable legislative and other measures within its available resources to progressively realize that right. And what we're talking about here is reasonable legislative and other measures to progressively realize that right. And the argument that I would make is that medical assistance in death is access to a healthcare service at the last stage of life. And what I want to say is that this Constitution, which so many people don't believe in these days, but they should believe in, has done a huge amount to protect and advance rights and has saved many lives, many, many lives. I was one of the founders of the Treatment Action Campaign back in 1998. We can literally say that the movement that we built around Section 27 of the Constitution has saved 7 million lives, because that's the number of people on antiretroviral treatment as you and I, as we are all sitting here this afternoon. It's cut the rate of mother-to-child transmission of HIV from 70,000 births a year to less than 1,000 births a year as a result of social mobilization and use of law. But that's not a reason to pat ourselves on the back. It's not a reason to rest on our laurels. AIDS is just one condition in a growing burden of life and dignity-threatening diseases. So now let me state the obvious. And I say this because I know that this is one of the criticisms that, or fears that some people have about our campaign as Dignity South Africa around medical assistance in death. The campaign for medical assistance in death doesn't absolve us of fixing the healthcare system as a whole, including massively improving access to pain management and palliative care and treatment, so that people who might wish that they could die because they live with so much pain could actually live with reduced pain and suffering because their symptoms are managed and because they get emotional and physical and medical support. And I see the campaign around medical assistance in death and palliative care as two sides of the same coin in many respects. And again, I make this point because I'm aware there have been tensions, there have been uncertainties. In response to an article that Lee wrote in 2025, a palliative care support group, WhatsApp group that I'm a member of, a person I respect a great deal, wrote, I'm not opposed to assisted dying for any moral or religious grounds. I simply believe that the vast majority of seriously ill patients and those treating them have a very poor idea of what palliative care is and how to relieve suffering, and that ending life does not necessarily achieve the latter. Now, that person who made that comment is right. Ending life does not necessarily achieve the latter for everybody. But if it does for somebody, and for some people, even if it's just one person, and we know that it's much more than one person, then it's a right. But Julia was right in her concern about the state of palliative care. Just a couple of days ago, there was an article in Ground Up titled, "Most patients do not receive important treatment during and after surgery." Its title was ANA, Study Shows Hospitals Are Botching Pain Management. This morning, I checked with my colleagues in the palliative care movement the conservative figure of the number of people with unmet need for pain management in South Africa, which of course is only a part of palliative care, is 700,000 to 800,000 people. And like most of you, I think that personal experience teaches me the importance of palliative care. Last year, on November the 2nd, my very close sister-in-law died of cancer after an 8-year battle. She died peacefully with us, surrounding her bedside, having stopped treatment a week before. But if it hadn't been for the palliative care nurse who came in, we would have suffered more, she would have suffered more. And the presence of that lady made a huge amount of difference to all of us. And what shocked me was the conditions in which that palliative care nurse had to live and work. Her low salary, the fact that she didn't get any remuneration for spending days and nights looking after patients. And I think we all have a duty to speak up for palliative care carers and for palliative care as a principles. I know I don't need to persuade Dignity South Africa of this because, as you've seen, it's already one of its 4 principles. So as I move to a conclusion, I just want to make 2 or 3 final points. Willem mentioned the issue of inequality. And I think that there is a clear inequality, dignity, dying nexus. Medical access, MAID is an inequality. Medical assistance in dying is an inequality issue. The poor in our country and across the world die in great pain, in very, very great numbers. And we need to remember that and try to have compassion and understanding with it. And the inequality is reflected in this. I just picked up an article in the Guardian, UK Guardian, a few days ago, where they talked about in the UK, there's a new term called chronically terminal. How do you live if you are chronically terminal? But that assumes that you have support and that you have medicines and that you have palliative care and that you have emotional support. I don't think that term has reached South Africa. I'm sure the term has reached that South Africa, but it's probably a fairly meaningless term to most people in our current context of our healthcare system. We have to change that as Dignity South Africa. We have to fuse the Dignity South Africa movement with the palliative care movement, with movements around access to cancer treatment, access to diabetes treatment, access to HIV and tuberculosis treatment, and so on. Which brings me to 2 last points. The question of resort to the courts, which is what Dignity South Africa has wisely decided to do. In the campaigns that I've been involved in using Section 27 and other issues, I've learned that there are issues for which courts are suitable and there's issues for which courts are not suitable. I think medical assistance in dying is the former. I think it is suitable. I think it's suitable because, as Willem outlined, advocacy, research, legal argument around this has been going on for a very long time. We're not starting with the courts, we are ending with the courts. It's a question of last resort where politicians and others have failed. Medical assistance in dying, in my view, doesn't have major resource implications. So it's not something where the state can say we don't have available resources. I believe it's lifting a prohibition, which actually could be done at the stroke of a pen. Although sensibly, we're not arguing for that. We're arguing for a 24-month suspension of any declaration by the courts to allow Parliament to fix it, which is the right thing to do. But also, I think that's an opportunity for widespread public education around this issue, on which there will be misunderstanding, on which there will be polarization, which will be abused and manipulated by some people who choose not to understand. I think it's suitable because it's for access to a healthcare service that de facto already exists. It's about prescribing medicines in many instances. It's just a different purpose in prescribing medicines. It's of clear benefit to the person who is living a life that has become unbearable and shouldn't and doesn't have to live that life and wants to die with dignity. And probably at the end of the day, it is something that would be utilized by a small number of people. And that's the final where I want to end, to bring us back full circle. It doesn't matter that it may only be a benefit, a right for a small number of people. Because as I began by saying, everyone is everyone. Everyone has a right of access to healthcare services. Everyone has a right of access to healthcare services. Our constitutional litigation is celebrated for making difficult and sometimes publicly unpopular decisions on gay marriage, on the death penalty, on the rights of prisoners, on the rights of people living with HIV. It's what distinguishes us and protects us from populist rule. And that is what we are talking about here. Because what underlies this is whether you are one person, 10 people, 10,000 people, or 10 million people, you have equal rights. Everyone is everyone. Nobody's dignity is a luxury or not worthy of protection. And this applies to people struggling with terminal or irredeemable conditions whose suffering is unbearable. We have that right. You have that right as well. And this is about claiming that private right. So I want to conclude just by saying this. Interesting, nuanced, complex, controversial as this issue is, it is not an academic question. It's a moral question, first and foremost, and then it becomes a legal question for me. I've read Dignity South Africa's founding affidavit. Thank you. The case studies, for want of a better word, the individual stories are deeply moving and traumatic, and it is easy to understand the pain and suffering of the people whose stories that are told and the people around the people whose stories are told. And what I've learned in my years in working with HIV and in the years when we spent a lot of time with people dying of AIDS and saw many of our friends die of AIDS in difficult and painful circumstances without dignity, is that our compassion should compel action on this. And you can't read those stories and not do anything, or not want to do anything. So this is about, for me, completing the circle of the right to healthcare from conception to death. We provide healthcare at the point of conception. We provide healthcare before life starts at birth, before life starts with birth, but when life has started after conception. We should provide healthcare to the last moment of life and in death. So it is about securing South Africa's last right. And that's perhaps when I woke up to the title of the talk that I was asked to speak to. So my closing appeal to all of us today is that when court papers are launched, it's going to provoke debate. It will be sensationalized. I hope not. I would appeal to the media not to sensationalize it, not to grapple with it, to understand the issues, not to misunderstand or misreport or misemphasize, and urge all of us here tonight who are members of Dignity South Africa or not members of South Africa to play a part in ensuring a debate that is balanced, informed, and compassionate, because there are human beings that this debate matters the world to. And I'll stop there. Thank you very much.